Requests for admission. Matters admitted under Rule 36 are conclusively established and generally cannot be contradicted at trial by the admitting party.
What happens if a party just refuses to cooperate with discovery?
The rules provide for enforcement. If a party fails to make mandatory disclosures or respond to a discovery request, the requesting party can file a motion to compel discovery under Rule 37A, after certifying they made a good faith effort to resolve the dispute informally. If the court grants the motion to compel and the party still doesn't comply, or if a party completely fails to show up for their deposition or respond at all to interrogatories or requests for production, the court can impose sanctions under Rule 37B. These can range from paying the other side's expenses to striking pleadings, deeming facts admitted, prohibiting the disobedient party from supporting claims defenses, dismissing the action, or even entering a default judgment. Sanctions decisions are reviewed on appeal for abuse of discretion.
Sanctions can be severe. What about electronic information? Losing emails or data seems like a big issue now.
Absolutely. Electronically stored information, ESI, has specific preservation obligations and sanctions rules under Rule 37E. If ESI that should have been preserved in anticipation or conduct of litigation is lost because a party failed to take reasonable steps to preserve it, and it cannot be restored or replaced. If prejudice to another party results, the court may order measures no greater than necessary to cure the prejudice. Only if the court finds the party acted with the intent to deprive another party of the information's use in the litigation, the court may A. Presume the lost information was unfavorable to the party. B. Instruct the jury it may or must presume the information was unfavorable. Or C. Dismiss the action or enter a default judgment. The finding of intent is critical for these harsher sanctions.
Intent is key for harsh ESI sanctions.
Yeah.
This whole process seems like it needs managing. Are there court conferences for that?
Yes. Case management is crucial. Rule 16 provides for pretrial conferences. The court may order attorneys and unrepresented parties to appear for conferences to expedite the case, establish early control, discourage wasteful activities, improve preparation quality, and facilitate settlement. The court typically issues a scheduling order early on, setting deadlines for joinder, motions, and discovery completion. A final pretrial conference is held close to trial to formulate the trial plan. Failure to participate in good faith or obey orders can lead to sanctions.
So after all the pleading, joinder, and discovery battles, not every case actually goes to a full trial, right? There seem to be several ways a case can end before that or even during the trial process. And then what happens after a judgment?
That's absolutely right. Many cases resolve through adjudication without trial. Let's look at the main ways. First, voluntary dismissal. Rule 41A. The plaintiff can generally dismiss their own case without a court order. By notice. The plaintiff can file a notice of dismissal any time before the opposing party serves either an answer or a motion for summary judgment. This first dismissal by notice is usually without prejudice, meaning the plaintiff can refile the lawsuit later, assuming the statute of limitations hasn't run. The two-dismissal rule. This is a key exception. If a plaintiff previously dismissed an action based on the same claim in any federal or state court by notice, a second dismissal of the same claim by notice operates as an adjudication on the merits, meaning it's with prejudice and the claim cannot be brought again. By stipulation. All parties who have appeared can sign a stipulation of dismissal, usually without prejudice unless stated otherwise. By motion court order. If dismissal by notice or stipulation isn't available, for example after an answer is filed, the plaintiff must ask the court for an order of dismissal. The court has discretion, and it's usually without prejudice, but the court can impose terms and conditions. The two-dismissal rule generally doesn't apply to dismissals by court order.
So the two-dismissal rule is only for dismissals by notice. What if the defendant wants the case dismissed because the plaintiff isn't doing anything?
That's involuntary dismissal, Rule 41B. A defendant can move to dismiss if the plaintiff fails to prosecute the case, for example, unreasonable delay, or fails to comply with the federal rules or a court order. Unless the dismissal order states otherwise, an involuntary dismissal generally operates as an adjudication on the merits, meaning it's with prejudice and bars refiling the claim. Exceptions exist for dismissals for lack of jurisdiction, improper venue, or failure to join a required party under Rule 19.
Okay, dismissals can be voluntary or involuntary with or without prejudice. What about default?
Default and default judgment, Rule 55, occur when a party against whom relief is sought, usually the defendant, has failed to plead or otherwise defend the action. The clerk first enters the party's default on the record. This establishes liability, but not damages. The defaulting party can ask the court to set aside the entry of default for good cause. After default is entered, the plaintiff must then apply for a default judgment. The court can enter it if the claim is for some certain and the defendant hasn't appeared. Otherwise, the plaintiff must apply to the judge, who may hold a hearing, for example, to determine damages. A default judgment can also be set aside under Rule 60B, for example, for mistake, excusable neglect.
Default happens if you don't show up. What's the big one for challenging the evidence before trial, summary judgment?
Summary judgment, SJ, under Rule 56, is a hugely important procedural device. It allows a party to win the case, or parts of it, without a full trial if they can show that. 1, there is no genuine dispute as to any material fact, and 2, the moving party is entitled to judgment as a matter of law. It essentially challenges the evidentiary sufficiency of the opposing party's claim or defense. Time to file. A party can move for SJ any time until 30 days after the close of all discovery. Burden. The movement initially bears the burden of showing the absence of a genuine dispute of material fact. They can do this by pointing to evidence, depositions, documents, affidavits, etc., that negates an essential element of the non-movement's claim, or by showing the non-movement lacks sufficient evidence to support an essential element. The burden then shifts to the non-movement to come forward with specific admissible evidence showing that there is a genuine dispute of material fact requiring a trial. They cannot just rely on the allegations in their pleadings, they must point to actual evidence. They can also ask the court to defer ruling if they need more time for discovery. Rule 56D, standard for granting. The court grants SJ only if, viewing the evidence in the light most favorable to the non-moving party, there is no genuine dispute about any fact material to the outcome, and the law dictates the movement must win. It's not about the judge weighing the credibility of evidence, but about determining if there's any triable factual issue for a jury or the judge in bench trial to decide. If reasonable minds could differ on a material fact, SJ must be denied.
No genuine dispute of material fact. Crucial standard. If a case does survive all that and goes to trial, what are the key procedures there, especially with juries?
Right, if summary judgment is denied, the case proceeds to trial procedure. First, jury trial, if applicable. The Seventh Amendment preserves the right to a jury trial in federal court for suits at common law, where the value in controversy exceeds $20. This generally means actions seeking primarily legal relief, damages, not purely equitable relief like injunctions or specific performance. If a case involves both legal and equitable claims, the legal claims, entitled to a jury, are generally tried first to the jury, and then the judge decides the equitable claims based on the jury's factual findings. Federal law determines the right to a jury trial, even for state law claims brought in federal court under diversity jurisdiction. Demand. A party must make a written demand for a jury trial no later than 14 days after the service of the last pleading directed to the jury triable issue. Failure to make a timely demand constitutes a waiver of the right. Jury composition. Federal civil juries must have at least 6 and no more than 12 members. There are no longer alternates. If a juror is excused for good cause during trial, the trial can proceed with as few as 6 jurors unless the parties stipulate otherwise. Challenges to potential jurors. Parties can challenge potential jurors. Each party typically gets 3 peremptory challenges, which can be used to strike a juror for almost any reason, except that they cannot be based on race, ethnicity, or gender. Batson challenges. Parties have unlimited challenges for cause if they can show a potential juror has actual bias or lacks impartiality. Jury instructions. At the close of evidence, parties submit proposed instructions on the applicable law. The judge informs the parties of the instructions she intends to give, allows them to object on the record before the instructions are given to the jury. Failure to object properly generally waives the issue for appeal unless it constitutes plain error. Jury verdicts. Unless the parties stipulate otherwise, the verdict must be unanimous and returned by a jury of at least 6 members. Verdict forms can be: special verdict, jury answers specific factual questions, judge applies law; general verdict, jury simply finds for plaintiff or defendant and awards damages, if any; or a general verdict with answers to written questions, a hybrid.
What if there's no jury? A bench trial.
Correct. In a trial by the court, bench trial, the judge acts as both the finder of fact and the decider of law. After the trial, the judge must issue findings of fact and conclusions of law under Rule 52A, stating the factual basis for the decision and the legal reasoning. On appeal, the judge's findings of fact are reviewed under the highly deferential, clearly erroneous standard.
During a jury trial, can a party argue the evidence is just too weak to even let the jury decide?
Yes, that's a motion for judgment as a matter of law, JNOL, under Rule 50A, historically called a directed verdict. A party can make this motion any time before the case is submitted to the jury. The standard is basically the same as for summary judgment, but applied after the opposing party has presented their evidence at trial. Viewing the evidence in the light most favorable to the non-moving party, is there a legally sufficient evidentiary basis for a reasonable jury to find for that party? If not, the judge can grant JMOL and take the case away from the jury.
What if the judge denies JMOL, lets the case go to the jury, and the jury comes back with a verdict the losing party thinks is unreasonable?
Then the losing party can file a renewed motion for judgment as a matter of law, RJML, under Rule 50B, historically called JNOV, judgment notwithstanding the verdict. This motion must be filed no later than 28 days after the entry of judgment, or jury discharge if no verdict. Crucially, a party can only make an RJML motion if they already made a JMOL motion on the same grounds before the case was submitted to the jury. You have to preserve the issue. The standard for RJML is the same as for JMOL viewing evidence most favorably to the verdict winner. Could a reasonable jury have reached that verdict? If the judge grants RJML, they essentially overrule the jury's verdict. The court ruling on an RJML can 1. Allow the jury verdict to stand, 2. Order a new trial, or 3. Direct the entry of judgment as a matter of law for the moving party. This 28-day deadline and the requirement of a prior JML are absolute keys for exams.
RJML requires a prior JML. Is there also just a motion for a do-over, a new trial?
Yes. A motion for new trial under Rule 59 can also be filed no later than 28 days after judgment entry. The court can grant a new trial, quote, for any reason for which a new trial has heretofore been granted in an action at law in federal court. Common grounds include prejudicial error by the judge, e.g. wrong jury instruction, improper admission of evidence, prejudicial misconduct by a party or attorney, newly discovered evidence that likely would have changed the outcome and couldn't have been found earlier with diligence, or if the verdict is against the clear weight of the evidence. Here, the judge can weigh credibility, unlike JMOL Sej. Granting a new trial essentially wipes the slate clean for a retrial.
And finally, after all that, a judgment is entered. Can it be changed or challenged later on? This sounds like post-trial procedure.
It's exactly. Post-trial procedure deals with finalizing or challenging the judgment. First, alteration of or relief from judgment. Under Rule 60A, the court can correct clerical mistakes or errors arising from oversight or omission at any time. Under Rule 60B, the court can relieve a party from a final judgment or order for specific reasons, filed within a reasonable time, and for reasons 1 to 3, no later than 1 year after entry. 1. Mistake, inadvertence, surprise, or excusable neglect. 2. Newly discovered evidence that diligent investigation couldn't have found earlier. Fraud, misrepresentation, or misconduct by opposing party. 4. The judgment is void, for example, lack of SMJPJ. 5. The judgment has been satisfied or discharged. Or 6. Any other reason that justifies relief, rarely used.
Okay, relief from judgment for specific reasons. What about going to a higher court appeals?
Appeals are the primary way to challenge a final judgment. Key things to know. Notice of appeal must generally be filed with the district court clerk within 30 days after the judgment or appealable order is entered. This deadline is jurisdictional and strictly enforced, though extensions are possible in limited circumstances. Final judgment rule. Generally, federal appellate courts only have jurisdiction to hear appeals from final judgments of the district courts. A final judgment is one that resolves all claims as to all parties, leaving nothing left for the district court to do but execute the judgment. This promotes efficiency by preventing piecemeal appeals. An exception exists under Rule 54B, where a district court resolves some claims parties but not all. The court can expressly direct entry of a final judgment as to those resolves claims parties if it finds no just reason for delay, making that part appealable immediately. Interlocutory review. Most orders made before final judgment, interlocutory orders, are not immediately appealable. Exceptions exist for orders granting denying injunctions, Section 1292. Discretionary appeal under Section 1292B if the district judge certifies the order involves a controlling question of law with substantial ground for difference of opinion. An immediate appeal may materially advance litigation termination. Discretionary appeal of class action certification orders, Rule 23F, and the collateral order doctrine.
Collateral order doctrine. What's that?
It's a narrow judge-made exception allowing immediate appeal of certain interlocutory orders that 1. Conclusively determine a disputed question. 2. Resolve an important issue completely separate from the merits of the action. And 3. Are effectively unreviewable on appeal from the final judgment. Think orders denying immunity. Writ of mandamus. An extraordinary remedy where an appellate court orders a lower court judge to perform a mandatory duty or cease an abuse of authority. Very rare.
Final judgment rule is key, but exceptions exist. When an appeal is heard, how does the appellate court review the district court's decisions? Different standards applied, right?
Yes. The standards of review are absolutely critical for exams, as they determine how much deference the appellate court gives to the lower court. Questions of law. Reviewed de novo. This means no deference is given. The appellate court decides the legal issue fresh, as if for the first time. If the district judge misinterpreted the law, the appellate court will reverse. Applies to SMJ, interpretation of statutes, rules, summary judgment grants, JMOL grants. Findings of fact, bench trial. Reviewed for clear error. This is wholly deferential. The appellate court will reverse the judge's factual finding only if it is left with a definite and firm conviction that a mistake has been committed. Just disagreeing isn't enough. Findings of fact, jury trial, reviewed based on whether supported by substantial evidence. Even more deferential than clear error. The jury's verdict must stand if there is substantial evidence in the record, viewed most favorably to the verdict, upon which a reasonable jury could have reached that conclusion. Discretionary rulings. Reviewed for abuse of discretion, also highly deferential, applies to decisions the trial judge has leeway to make. For example, granting injunctions, admissibility of evidence, discovery sanctions, motions for new trial, leave to amend. The appellate court reverses only if the district court's decision was arbitrary, capricious, or manifestly unreasonable.
Okay, we've followed a case from start to finish, including appeals. To wrap up our deep dive, we absolutely need to cover two critical doctrines that prevent parties from endlessly refighting battles. Preclusion, and then hit those all-important deadlines one last time. These seem like concepts designed to bring finality and efficiency.
You've hit on two incredibly important and often confused doctrines: claim preclusion, res judicata, and issue preclusion, collateral estoppel. They both promote finality and judicial economy, but they operate differently. When you see a bar exam question involving a prior judgment, Judgment 1, and a new lawsuit, Lawsuit 2, your approach should always be systematic. First, ask, is the entire claim in Lawsuit 2 precluded by Judgment 1? Apply the elements of claim preclusion. If yes, you stop there. Lawsuit 2 is barred. Second, if the claim itself is not precluded, then ask, are any specific issues that must be decided in Lawsuit 2 precluded because they were already decided in Judgment 1? Apply the elements of issue preclusion.
Okay, claim preclusion first. What are the elements?
Claim preclusion, res judicata, bars a party from suing on a claim that has already been decided by a valid final judgment on the merits, or that could have been brought in the earlier suit. The goal is to prevent relitigating the same cause of action. The elements are: 1. Valid final judgment on the merits. Judgment 1 must have been final, valid, court had jurisdiction, and based on the substance of the claim, not just dismissed for a jurisdiction, venue, or failure to join party. Most dismissals with prejudice count as on the merits. 2. Identical claims, or same claim. Lawsuit 2 must involve the same claim as Judgment 1. Most federal courts use the transactional approach. Claims are the same if they arise from the same transaction, occurrence, or series of connected transactions. This means claim preclusion bars claims that were litigated and any related claims arising from the same nucleus of facts that could have been raised in the first action. 3. Identical parties, or parties in privity. Lawsuit 2 must involve the same parties as Judgment 1, or parties who are in privity with them. For example, successors in interest, persons whose interests were represented. The parties must generally be in the same configuration. For example, PVD in both suits.
So, same transaction, same parties, final judgment on merits equal no second lawsuit on that claim. What if it's a different claim but involves an issue already decided?
That's where issue preclusion, collateral estoppel, comes in. It prevents parties from relitigating specific factual or legal issues that were actually litigated and decided in a prior case, even if Lawsuit 2 involves a completely different claim or cause of action. The elements are: 1. Identical issue. The issue sought to be precluded in Lawsuit 2 must be the exact same issue of fact or law that was involved in Judgment 1. 2. Actually litigated and decided. The issue must have been actually raised, contested by the parties, and submitted to the court or jury for determination in the first case. Default judgments generally don't satisfy this for issue preclusion. 3. Essential to the judgment. The decision on that specific issue in Judgment 1 must have been necessary or essential to the court's final judgment. If the judgment could have stood on other grounds, the finding might not have been essential. 4. Valid final judgment. Same as for claim preclusion. 5. Party against whom preclusion is asserted. Issue preclusion can only be asserted against someone who was a party, or in privity with a party, in the first lawsuit, and had a full and fair opportunity to litigate the issue there. You can't bind someone who wasn't involved. Issue preclusion can sometimes be used non-mutually by someone who wasn't a party to the first suit against someone who was. But courts look carefully at fairness factors.
Okay, claim preclusion bars the whole claim, same transaction. Issue preclusion bars specific issues actually litigated and essential, that distinction is vital. And finally, as promised, those deadlines. Every attorney needs these burned into their memory. Let's hit the highlights one last time.
Absolutely. You can't practice procedure without knowing the clocks. Here are some of the most common and crucial deadlines for the federal rules. 14 days. That's often for responses after something else happens, like answering after a court denies your pre-answer motion, filing a third-party complaint without needing court permission after your original answer, responding to an amended pleading, submitting the proposed discovery plan after the Rule 26F conference, demanding a jury trial after the last pleading on that issue. 21 days. This is a big one for initial responses. Serving your pre-answer motion or your answer itself, amending your pleading once as of right, holding that Rule 26F discovery planning conference, at least 21 days before the scheduling conference, serving a reply if one is ordered. 28 days. Think post-trial motions here. That's the deadline for renewed JMA4, Rule 50B, motion for a new trial, Rule 59, motion to alter or amend judgment, Rule 59E, motion for amended findings in a bench trial, Rule 52B. 28 days after judgment entry is key. 30 days. Lots of important ones here, often related to removal or discovery responses. Filing the notice of removal after receiving the initial pleading, filing a motion to remand based on procedural defects after removal, making pretrial disclosures before trial, responding to interrogatories, Rule 33, requests for production, Rule 34, or requests for admission, Rule 36, filing a motion for summary judgment up to 30 days after discovery closes, and critically, filing the notice of appeal after judgment entry. 60 days. Remember waiver of service. If a defendant in the U.S. waives formal service, they get 60 days after the request was sent to file their answer. 90 days. The plaintiff generally has 90 days after filing the complaint to serve the defendant, Rule 4 meter. Also, if a defendant outside the U.S. waives service, they get 90 days to answer. And expert witness disclosures are typically due at least 90 days before trial. Knowing these specific timeframes, 14, 21, 28, 30, 60, 90 days, and what triggers them is absolutely crucial for both practical application and, of course, for spotting issues on the exam.
And there you have it, a truly, truly deep dive into the sometimes labyrinthine world of civil procedure. From those fundamental questions of a court's power jurisdiction all the way through the strategic dance of discovery, joinder, trial, and the finality brought by judgments and preclusion. We've really tried to unpack the essentials. We've aimed to hone in on those nuances, those tricky spots like the well-pleaded complaint rule, eerie, waiver traps, relation back work products, standards of review, the things that often trip up exam takers, hopefully giving you a solid analytical framework for whatever complex procedural problem comes your way.
That's absolutely the goal. Remember, it's not just about memorizing rule numbers. It's about seeing the threads, how these rules connect into a system, understanding why they exist, the connection to due process, to judicial efficiency, to ensuring fairness for everyone involved. That's what transforms rote memorization into real comprehension. That's what lets you build compelling arguments, whether it's in an exam essay or in practice.
So as you continue studying, really think about the journey of a lawsuit. Picture it moving from filing to appeal. How does each rule we discussed shape that path? How does it try to balance efficiency with fairness? How might just one small change in the facts, a defendant moving, a key witness disappearing, a document getting lost, completely alter the analysis of jurisdiction or venue or discovery sanctions or even preclusion down the line? That interplay is where the deep understanding really happens.
We genuinely hope this deep dive has given you not just the rules, but the confidence and, importantly, the analytical tools to navigate the intricate landscape of civil procedure. Keep asking those why questions. Keep connecting the dots between the different doctrines. And always remember that critical thinking, that ability to apply the rules to new facts, is your most valuable asset.
Thanks so much for diving deep with us today. Until next time, keep being insatiably curious.